Hi everyone. We are talking about something that has shaken the almost every community that is on visa in the UK. So of course our inboxes are full, phones are ringing non-stop, and lot of people are genuinely scared and anxious. So, what we wanted to do, we wanted to sit down and then, after reading the full consultation paper, listening to the Home Secretary's statement, listening to the parliamentary debate, listening to the other lawyers, and bring you something which is calm, detailed, and practical. So, very quickly, here is what we are going to cover today. So, you will find time steps in the description so you can jump to what you need. We'll be talking about what ILR actually is today and the current requirement, what the government is proposing in this new unsettlement consultation. The third one is how this could affect your route skilled worker, whether it's dependent visa, healthcare worker visa, or student planning to switch, or high earning or business focused migrants. And the fourth one is we'll share two real lifestyle scenario based on people who have consulted us recently. Fifth one is what you should realistically do during this consultation period. And sixth and final is something very practical that have been created to help you stay safe on the compliance side, which can directly affect your future ILR. So if you cannot wait at all, and you just want the most beneficial piece of this video, especially if you and your company hold a sponsor license, you can skip ahead or to the last sections. Now, with that said, I have been joined by Mr. Sunny Sandhu and Ikra Ahmed, our senior UK immigration advisor with years of experience in ILR and complex settlement cases. So, Sunny and Ikra, thank you for joining.
Thank you very much. Yeah, as you've said, this is one of those moments where you can really feel the kind of fear and anxiety in the client calls, and the influx of calls since it was introduced has been pretty crazy. So yeah, it's really good for highlighting that. So I think what's important for us to do now, and I think what Ikra will go into, is we want to really slow this down, give people a full understanding of what's going on, try and hopefully alleviate some of their fears. And Ikra will go through three very clear things that we want to focus on the start.
Yes, absolutely true. Thanks, Sunny. Thanks, Yash. Number one, this is a consultation. It is not law today, so it's not final. Number two, the paper talks about principles and models. Like I said, not every detail is final. And number three, your case is individual. This episode is general information, not specific legal advice. If you remember just those three things, you will already feel a bit more grounded.
Thank you, Ikra. And just to frame it for everyone, what has actually been released is a consultation paper on something called an unsettlement system. It's about 65 pages and it's open to public response until 12 February 2026. And it sets out how the government is thinking about future ILR, rules for people who have not yet reached settlement. So, if you already have ILR, this doesn't apply to you. If you are on the journey to ILR, if you are, let's say, in year 2, 3, 4, this is the episode for you. So, next one is, what is ILR, right? Before we talk about even 10 years, 15 years, ladders and pillars, can we do something very simple, right? Really simple. For someone who is watching this video, only knows the word ILR from social media. So what is ILR today, and what do people need to get it under the current system? Ikra, if you can explain, please.
Actually, I love that we picked this up first. Let us strip it down. ILR is essentially indefinite leave to remain. It is not a passport. It is a step before British citizenship. But it does give you the step that gives you stable long-term residence. So today, under the current rules, you really have three big questions to start with. Number one, are you in a visa category that actually leads to settlement? Number two, have you spent the right number of years in that category without breaking the rules? And number three, do you meet the key requirements? For example, the English language, the life in the UK, the good character test. So for most viewers, that means things like skilled worker route, 5 years, spouse or partner route, often 5 years, but it can be 10 years as well. So we need to be careful with that. Also global talent visas, which is sometimes 3 years if you meet the criteria.
Thanks, Ikra. Yeah, do you know what? And just in addition to that, the student visa and the graduate route do not lead to the standard 5-year settlement. And that's something that has actually carried on for a number of years now. So that's important to remember. People get very confused about this, and we do get a lot of calls about this. They think 2 years as a student, 2 years as a graduate, and then maybe 1 year as a skilled worker, and then bang, I've got my ILR. And then sometimes it can be quite a hard reality. So it's important to make sure people remember that. There are also some work visas that actually don't ever lead to settlement. The old style intra-company visas, intra-company transfer visas on the global mobility route. Some people have spent 5 years on those visas and then discovered they cannot get ILR. So the very first thing to do today is always to check whether or not you actually are on a route that leads to settlement.
Oh, yeah, of course. So that's interesting. So if I'm watching this and I think I'm close to ILR, step one is not to count years on a calculator. It's to ask, does my route actually qualify for settlement or not? And if yes, what is my qualifying period under the current rules, right, Ikra?
Exactly. Then after that, you have continuous residence. So under the 5 years rule, for many work and family routes, you need to show that over that qualified period, you have not been outside the UK for more than a certain number of days in a 12-month rolling period. So a lot of our clients actually get confused thinking that it's always January to December, but that's actually incorrect. The Home Office have changed things. They said this is not how the Home Office see it. It's any 12 months within those 5-year period. Then you also have the English language, which is usually at B1 for many settlement applications today. Then you have the Life in the UK test, which is surprising number of people fail because they just underestimate the difficulties of it. And then you have the good character test, which is not just about criminal cases, but also other things like serious tax issues, unpaid government debt, repeated penalties, and so on.
Yeah, and just again, going on from what you said, Ikra, your documentation needs to be aligned. For example, you'll have skilled workers. That means, when I say documents need to be aligned, you'll mean things like payslip, bank statements, proof of salary, an employer letter, and also that your sponsor has actually remained compliant in those years. So there are lots of factors that people have to take into consideration. And even before this consultation, ILR was never simply as, 5 years leads to settlement. There, you've already seen a few layers already to this.
Yeah, and which is really important because what the consultation is doing now is taking those layers and adding a new model on top of them. So let's now talk about what is being proposed in the consultation, and then we'll connect it back to what you just explained. So if you had to give the simplest version to someone, Sunny, in an elevator, how would you put it to a layperson?
In very simple terms, the government is proposing that the standard period qualifying for settlement, which is often 5 years at this point, or in most cases 5 years today, becomes 10 years for most migrants. And on top of that, for some of the worker routes at lower skill levels, especially enrolled skilled below the a degree, what the Home Office would consider a degree level, the journey may even become 15 years, and especially in those in care roles. For some protection-based cases like refugees, there is a talk of a 20-year route as a starting point with the possibility of maybe earning a reduction. And alongside that, there is a new idea called earned settlement, where you can potentially reduce that 10-year period if you meet certain contribution and integration criteria, or it can possibly be extended if there are things like breaches, like overstaying or heavy reliance on public funds. So I think the best thing to do is think of it like this. Today you have fixed time plus requirements. The proposed future is you have a baseline time plus a scoring model that can adjust the time maybe up or down.
Wow, that's interesting. So we have fixed model and then it goes up and down. So that scoring model is where we see those 3 ladders on social media, right, Ikra?
Correct, yeah. So even though the consultation does not literally call them ladders, that is how they are being presented online. So one ladder is high income, another ladder is high skill or specified public service roles, Then you have one ladder, which is integration and community contribution. Then on top of this, you still have the 4 pillars that the paper formally sets out. So that's character, integration, contribution, and residence. So I'm just going to go into a little bit detail about each. So character is non-negotiable. So if there is a serious criminality or serious breaches, that can block you from settlement, and there is no trading that off with extra salary or volunteering. Integration includes language and life in the UK, test, and potentially other ways of showing you are engaged in British society. Contribution is heavily linked to earnings and tax. For example, the consultation mentions a minimum earned income level connected to the income tax threshold, and then a much higher level like over 50,000 for 3 years or 125,000 for 3 years that could reduce the qualifying period by several years. Residence is the local continuous time in the UK, similar to today, but with the twist that residence alone is not enough.
Right. I think there's a correction. So for I think 50,000 is 5 years and over 125,000 is 3 years. That's what I understood, right?
Yep. So my apologies. Yep. So 50,000 is 5 years, and then over 125,000 is 3 years.
Yes. So the key shift is that time alone is no longer the main story. That's interesting. So it becomes time plus how you have behaved and how you have contributed and how you integrated in the UK, right, Sunny?
Exactly. And again, it's what we are saying is this is purely a description. It's not an approval or a criticism.
Yeah. So how about let's go route by route, and this time let us go a little deeper. So especially for skilled workers, dependents, and care workers, because that's where the majority of questions sit. Starting with skilled worker, Ikra, is it true that under the current rules, many skilled workers can apply for ILR after 5 years on eligible work routes if they meet salary, continuous residence, and the requirement you mentioned before?
So it's yes and no. Under the consultation, that default path moves to 10 years. So if I am a skilled worker arriving now, I will be planning in this model for 10 years of local residence before ILR and not 5 years. Then we have the skill level issues. For those, as Danny's mentioned before, below degree level, which includes many tier roles and some other low-wage occupations, the paper is asking whether their baseline should be extended to 15 years. Because the government believes that these categories are less likely to make a positive contribution over the long term. So 2 big questions if you are on the skilled worker route and watching this is, number 1, is your occupation or job below degree level? And number 2, what is your long-term salary trajectory? Because these 2 things will interact with both the 10-year baseline and possibly 15-year extension.
That's interesting. So, but what about the dependents? Because this is where the minds are blown. People still assume that if the main applicant qualifies, the whole family goes with them. Is that still correct, Sunny, or something has changed there?
Well, right now in many work routes, this is still roughly the practice. Dependent does not need to meet any separate earnings. They mainly need to meet their own really like English and life in the UK test and documentation to prove that they're still in a relationship and it's a genuine and that's still ongoing. But this is where the huge but. The consultation clearly says that under an earned settlement scheme, they expect dependents to have separate conditions and not simply ride on the main applicant. This could mean that a partner and child might need to show their own integration, their own absence record, and possibly their own contribution, whether that be economically or otherwise. Paper even hints that children and dependents might need slightly different tests. But the key message is this: the idea that you just wait for the main applicant to hit 5 years and then everyone automatically gets ILR, that's what's seriously being questioned at the moment.
That's getting tough, right? So one very practical thing for families to take from this episode is that everyone in the family should understand their own timeline and route, not just the main applicant. Is that right, Sunny?
Yeah, exactly. And do you know what? We actually had a client some time back, very, very similar situation. I think, Ikra, you handled that one.
Oh, yes. Yeah, I did. We will discuss it a bit later today.
Oh, okay, perfect. So I remember that. But before we go there, Sunny, can you please tell us how will this change impact the care workers and people in the health sector?
Yeah, sure. This is actually quite emotional because in reality, especially during the pandemic, care workers and health teams really kept the system running all the way through the pandemic. And many came here, brought partners and children, and they are often on the salaries that are not extremely high compared to other skilled worker categories.
Yeah, it's so true. And I'm also very moved with this proposed consultation. And if I'm not wrong, the consultation mentioned the large share of the recent immigration is in health and care route, with high dependent ratio and significant projected cost in terms of access to services and potential benefits after settlement. What do you have to say, Ikra, about that?
Yeah, that is true. So this is why the paper asks about a 15-year journey for those who were sponsored in roles below degree level, including many care roles. So if you are a care worker watching this or a spouse of a care worker, the proposal is essentially saying that we want you to have a longer standard path to settlement. We may overlay an earned settlement model on top of that, and we are asking whether access to public funds should be restricted until citizenship, even if you have ILR. Again, not our opinion, just what the consultation is discussing.
Right. So this is not very nice or encouraging news for those under RQF level 6 or working in care industry as a carer and lower skill job. I mean, it does appear to be very disappointing news for those. Now, if we were to explain these three letters with a more grounded example, let's say social media is full of those three letters as we see and as we have noticed. So let us slow them down and link them to a real human situation. So the first letter is high income. So Ikra, would you mind please explaining a bit about the first letter, which is high income?
The consultation has an example where someone who earns over £50,000 for at least 3 years could potentially reduce the 10-year period by 5 years. There is also a higher bracket at around over 125,000, which gives an even bigger reduction in some tables. So imagine a client in finance, technology, or engineering who is already on a high salary. At that moment, they expect 5 years, and that is it. Under the new model, they might face 10 years as a baseline, but because of their earnings, they could potentially come back closer to 5. So in practice, this means that high earners maintain something like the old timeline, but through a different logic. They are not being given a privilege for free. The argument in the consultation is that they have already shown a strong and measurable contribution.
Right. So if I was just to simplify as a layperson, and if I'm earning 125,000 or more, then I'll be laughing at it, because if I am earning 125k, let's say on skilled workers for 3 years, I'll be getting my ILR quicker than previously 5 years prescribed period. But if I'm under 50, I'll be crying because it means it's 10 years, right? But I think majority of our clients, the clients we help, are probably a bit more than 50,000. So in practical terms, it doesn't affect those who are earning just above £50,000, right, Ikra? What do you
That's
think?
correct, yeah.
Right. Now, let's move on to the second ladder, which is the high skill or public service roles. Ikra, what is that?
So these are roles that the paper calls specified public service occupations. So things like senior clinicians, consultants, some specified specialized health roles, senior researchers, certain public service positions where the government sees a strong public benefit. So if you have worked in such a role for a certain number of years, the model suggests that you could also see a reduction of 5 years off the 10-year baseline.
Okay.
Yeah, and just going on from that, what we currently have had people consulting us who are in senior hospital roles. So they're already here on the global talent or similar fast track routes. And for them, this model might not feel so negative because they already sit in that high skill, high impact bracket.
Right. Yeah, that's interesting. So if you are in this public service roles, you might probably qualify in 5 years. That's probably a rough guideline. That's what I gauge from this model and this second ladder, right? Now, moving on to the third ladder, the integration and community contribution. So this is one Shabana Mahmood mentioned in the debate when she talked about recognizing those who contribute and play their part in the British society. So, what do you have to say about that, Sunny?
The idea is that people who have generally integrated, who volunteer, who are active in their local community, who regularly participate in like civil life or local authority life, could earn a reduction on their ILR. And we're not sure specifically how small that reduction or large that reduction would be. For example, one of the examples on the table that is that a higher English language level at C1 instead of B2 could reduce 1 year from your qualifying period.
Okay.
Because at the moment, the ILR, they say for ILR, you need to have B1. So giving that kind of incentive for people to get a better understanding of English and further themselves, it also gives you the incentive to get ILR quicker as well. There's also talk about community work, structured volunteering that might reduce a year or two, but at this time, it's important. Politicians themselves have already flagged the risk of gaming. So you can expect any future rules here to be drafted extremely tightly. In summary, ladder 1, high income, ladder 2, specified high contribution roles, ladder 3 is integration and perhaps advanced language and community work. And all of that sits on top of the 4 pillars and the 10-year baseline. It's not independent.
That's really interesting. Very interesting. Simple. So baseline is 10 years. Then we have pillar 1, which is ladder 1 is high income, ladder 2 is specified high contribution role, public roles, I guess, and the ladder 3 is the integration and perhaps the advanced language and community work. Okay, that's clear to me. Now, let's make this real with 2 scenarios. We have actually seen people consulting with us, and Sunny, you were also mentioning something earlier of an example that Ikra might have looked at. So again, for our audience today watching this video, these are general examples. This is not advice for your exact case. They are just the general examples. So please do not treat it as a professional legal advice. Legal advice should be sought very personally, and you should seek a professional legal help if you are not sure about your personal case, please. So first that comes to my mind is a skilled worker visa, right? So let's say someone is in a skilled worker visa in year 4 in a professional role, earning just above the skilled worker threshold with a partner and 1 child as dependent, and they have had higher absences in 1 year due to a family emergency back home. What does their world look like under the current system and then under the proposed model? Sunny, if you could comment, that'd be great, please.
Sure. Well, right now, today, under the existing 5-year ILR route, the key question for this person is their role one that leads to settlement? Are they meeting the going rate and salary requirement for the skilled worker? And do their absences stay within the allowed limits over the 5-year period, counting any 12-month rolling window, as Ikra mentioned earlier, not just the calendar years?
Yeah.
So does the partner also reach 5 years by the time they apply? And do they both meet the English language and life in the UK test? And if they are in year 4, our current advice is usually very practical. We sit it down with the calendar, we check their absences, we check their pay, we check their sponsor license, their strength, and we make a plan for the final year.
So under the consultation model, if the changes begin in 2026 as proposed, the question becomes more layered. So if they reach ILR before the rule changes, they should fall under the current regime with transitional protections. If they do not, then in the new model, their 10 years of local residence become the new starting point. The high absences year might not break their case completely, but it could interact with the residence and possibly integration pillar and extend the qualifying period, especially if there were any breaks in permission. Their income, if it is only just above the threshold, might not be enough to give them any reduction through the high income ladder. Their partner would no longer simply attach to their application. The partner will need to show independent continuous residence, independent absence compliance, and meet all core requirements.
Well,
That's interesting. Yeah, I have one question in between. So we're talking about the transitional arrangement, but we don't have any clarification or guideline in consultation about a proposed transitional arrangement. Is that right? I mean, there might be or there might not be any transitional arrangement. That's what I'm getting from the consultation so far. Any comment from you, Ikra?
At this moment of time, you're right, there is no comment. But personally, just how previous major immigration changes, there's always been a transitional requirement.
Yeah.
There's always been something transitional. For them to all of a sudden have no transitional, I do feel it'll be very unfair. Who knows? The Home Office may simply just say it applies for everyone. But personally, what I do believe that if someone is very close to, let's just say, 1 year of qualifying or even 2 years, there may be a cut-off period. Let's just say someone applying by those eligible by December 2027, they can remain on the old route. But this is just thoughts.
Yeah.
But who knows what will happen?
Yeah. Yeah, no, I agree with you because I do remember we've been practicing UK immigration for now over 17 years, right? So I do remember a case of HSMP where government had to change the rules to not apply retrospectively. So there is a possibility. That's our best guess. We might be wrong. We might be right. We don't know. For viewers, we have no indication what it might look like, or with or without transitional arrangement. So let's wait and watch. But meanwhile, over to you, Sunny.
Yeah, so going back to the example you raised with the ILR potential applicants who've had a year out, currently here for 4 years and are close to getting their ILR. In a session with someone like this, where, as Ikra mentioned, we're now thinking about 3 layers. So thought term, can they realistically test the current 5-year rule before any change? And as you guys know, we're not sure about the transitional arrangement. So can you get onto that 5-year rule as quickly as you can? What is their salary trajectory would be the medium term one? And is there room to grow into a high income bracket? And then long term, how do we protect your absences, tax record, community ties, so that they are not penalized under the current earned settlement model? That's the kind of conversations we're already having with people in year 3 and year 4 of their visa.
Yeah, it's very very interesting time, and I can relate to people, how anxious and concerned they are. I was a migrant myself as well, so I can imagine how difficult it is for them to go through this uncertainty for few months till government was to publish the new immigration rules whenever it was to come in place, which might be probably early next year. So now let's talk about the second scenario. Someone, let's say, on a health and care skilled worker visa, working as a care worker, and they arrived with their partner and 2 young children. And they are in, let's say, year 3 now, and their salary is at the lower end of the skilled worker salary bands, which is typical for care workers. So we have had a lot of care workers and their spouse consulting us with exactly this profile or similar to this profile. What are the things they should be aware of when they hear the words 15 years route and unsettlement, Sunny?
Yeah, thanks, Yash. This one's very real. Under current rules, a family would be thinking in terms of 5 years for the main applicant and 5 years for the partner. Children would usually follow the parents, so that would just be 5 years for all of them. So in their mind, they came with a plan: work hard, stay compliant. After 5 years, keep our head down, and we can apply for ILR and then maybe citizenship a year later. Now they open social media and see clips of people mentioning 15 years for care workers, no benefits until citizenship, dependents needing separate criteria, and they panic. Ultimately, they panic. And then the Home Office also saying dependents may not be able to come in with care workers anymore. So there's a little bit of hysteria now flying around.
That is true, Sonny. So talking about the proposed consultation model, there are several layers to think about. First, the baseline. The paper explicitly talks about increasing the qualifying period to 15 years for workers sponsored enrolled below RQF level 6, which is where many care roles sit. So the main applicant may be looking at 3 times the timeline they imagined. So unless they move into a higher level, a higher skill level role or another route. Second, the contribution and income. The care worker might meet the basic tax and national insurance threshold for 3 or 5 years, which is likely to become a minimum requirement for many applicants, but they may not reach those higher income brackets and reduce the qualifying period. So they might not benefit from the high income ladder unless they progress into more senior roles with significantly higher pay. The third, the dependents. So under the current system, the partner would simply apply with the main applicant once they have 5 years, as Sunny mentioned. And they would focus on relationship evidence, English, and life in the UK test. Under the earned settlement model, the partner might need to show their own journey. That could include length of residence, integration, possibly even some contribution if they are working. Fourth, the public funds and benefits. The consultation is asking whether some benefits should move from settlement stage to citizenship stage. That means this family could in future potentially have ILR but still be restricted from claiming certain public funds until they become British citizens.
Someone with this profile sits down with us, we do not just give them instructions. We have to look at their bigger life picture. Is there a realistic path for the main applicant to move into a higher band role, have training up into a more senior held position? Is the partner in a position to build their own career or integration story so that they are not left behind when the main applicant qualifies? Do the family need to adjust their financial planning because a longer journey now to full access to benefits changes how you approach savings, children's education, housing? It's a lot to really consider now for families. And again, we repeat, this is a proposal, it's not the law. But it's much better to start thinking in these directions now rather than being shocked in year 8. And like we said, the shock factor has already hit quite strong. So these are conversations that need to be had.
Yeah, so true. Yeah, just to repeat one more time, this is a proposal and it's not a law. But in my humble opinion, the way I say it might become a law, it's more likely to become a law than not, with some minor tweaks. That's my best guess. Again, I might be wrong. But I really like how you framed it here, Sunny. And it's not about scaring people. It's about saying, hey, if you are a care worker with dependents, these are the types of things that might matter a lot more in next few years, right?
Precisely. This is a generic scenario, a general one, not specific legal advice, what people have to remember, but it does show how deep these changes can really affect someone's life story. So it needs to be taken seriously.
Right. So this is a very, very, very interesting time for people on visa en route to settlement, permanent residency, ILR, indefinite leave to remain. So based on this, what you have listened so far, what should people actually do between now and 12th February, apart from watching every video on YouTube and panicking in the comment section? So, Sunny, 3 things you can talk about if you could.
Yeah, so there are 3 things. I'll let Ikra go through first 2, and then I'll
Okay.
back up another thought.
Yes,
Yeah, so as Fanny mentioned, there's 3 things everyone can potentially do. Number 1, educate yourself from the source. Read at least the summary sections of the consultation paper. Understand the 4 pillars and how the baseline of 10 years works with the adjustments. Number 2, if you feel these proposals would unfairly impact you, your family, or your community, respond to the consultation. You can do this as a migrant, as a British spouse, as an employer. The form lets you give structured answers and examples. This is where you can say, for example, I am a care worker in year 3 with 2 young children, and here is what 15 years would mean for us.
Interesting.
Yeah. And 3 is what we would propose is use this checkbox to clean up your own files. So check your visa history, check your absences, check your tax and national insurance record, and check your relationship documentation. I mean, even under the current system, these are the areas that cause ILR refusals and delays. Under an earned settlement model, they can become even more crucial. So having a checklist is very important.
Wow, wonderful, wonderful. Ikra, I like what you said earlier. You know, people should participate in consultation because this is consultation. Government is inviting opinions, comments from the wider section of the society. So I want to repeat one more time. Please, please, please do participate in this consultation. If it's affecting you, of course, you want to say something about it. If you don't try, you won't get there. So please do take part. And of course, we will put a link of this consultation in the description. It might take 5 minutes, 10 minutes, 20 minutes. Worth investing your time for your own sake. Or you ask your friends and family, your employer to do that for you as well. So as Ikra mentioned, anyone who is British, migrant, employer, they can participate and provide a response to this consultation. The more responses a government gets, that will then shape the future of UK immigration. So I would not miss this opportunity to invite you all to participate if it affects you. Please do that for you and for family, friends you know or you love. Might change the course of the action of the government based on this a wider response they receive on consultation. So going back, if someone is due to apply for ILR in 2026, 2027, what is your general message to them today, Sunny?
Honestly, it would be start preparing earlier than you think. Today, we already tell people to start at least 8 to 12 months before their planned ILR due date. Under a more complex system, that early planning becomes even more important. We don't really know the depth of how much planning we're going to need to do and how much settlement we're going to have to prove. So it's important just to start planning as soon as possible.
Yeah, and before we end, let's just talk briefly about the timeline and the future. It's in a very grounded way. So the first one is the key dates people should keep in mind. And please feel free to jump in anytime. Right now, the consultation is open until around the middle of February. After that, the government will review the responses and announce its final proposals. So the Home Secretary has already said in Parliament that they expect to start facing changes from April 2026, because that is when many people who came under the 2021 rules first become eligible for ILR under the current 5-year route. So for some viewers here on this video, there may still be a window to reach ILR under current rules before anything changes. And for others, especially those at the start of their journey, it's safer to plan on the basis that you might be living with an unsettlement model. But again, details can evolve, it can change. We don't know the finality of the new changes, but the final model may look different from the consultation draft depending on the responses. So please do take part now. If you have few minutes, please spare those few minutes, take part in the consultation and have your say there. So the new model may change again depending on the consultation draft, depending on the responses and legal scrutiny and technical practicalities. Of course, the government has to think the legal scrutiny of that and technical practicalities of those changes. So it is a big change in direction, but the story is not finished yet. Right, Sunny? Over to you.
Exactly. In the meantime, the things that have always mattered still matter, and that's incredibly important. So there might be a change of years, but in order to be eligible for ILR, the normal things still matter. So lawful resident, compliance, clear documentation, English past life in the UK test, good character. These are not going to go away. And if anything, they are just being reinforced.
Absolutely, yes. And then before concluding remarks, I want to show you both something really interesting. So people often think ILR is only about the migrant side, but for skilled worker, the Home Office will look at your sponsor as well. And if your sponsor license is non-compliant, has incorrect records, or is at risk of downgrade or suspension, that can directly affect your ILR journey. So we have seen people consult us whether their personal documents were fine, whether there were issues on the employer side. Because of that, our team has built a sponsor license compliance tool. If you are a business that holds a sponsor license, you are a skilled worker who wants to know how safe your sponsor is, this tool lets you run through the key areas that the Home Office focuses on and see whether you are broadly on track or whether there are red flags. So it's not a substitute for a full audit, but it's a very basic but very good early warning system. So if you are watching this and you hold a sponsor license, or your future ILR depends on employer's license, please take a few minutes to go through that tool. If the flag issues, don't wait. You can find the link in the description, and please take few minutes to do this basic check on your sponsor license compliance now. Now let's put the disclaimers on the table one more time very clearly. This is a consultation, not current law. Your situation is unique. You should not make major life decisions like resigning from a job or changing your route just on the basis of this one video. If you are in a complex situation, get personalized professional legal advice from a qualified professional who can look at your full immigration history. And Ikra, do you have to add anything here?
Yep. And at the same time, do not shut down and ignore it. These proposals are serious. They are likely to shape the way settlement works in the UK for many years. So use this time to educate yourself. Respond to the consultation if you can. Start quietly organizing your documents and your long-term plan.
Thank you, Ikra. And if you would like us to do a follow-up episode on very specific angles, like how absences work in detail, or what document you should collect during your 5 or 10 years, or how salary changes interact with ILR, tell us in comment now. We are reading, and we will read everything, because we are designing our next videos based on your questions. So thank you for staying with us through this longer and more detailed conversation. And thank you, Ikra, and thank you, Sunny, for your participation. It was really helpful and much appreciated. Thank you so much.